Statutes have become the primary building blocks of the modern American legal system. Some legal scholars call this phenomenon the statutorification of American law, but political processes and legislative compromises often result in statutes that are ambiguous, broadly worded, or otherwise unclear. 20th century Supreme Court Justice Felix Frankfurter defined a statute as, quote, an instrument of government partaking of its practical purposes, but also of its infirmities and limitations, of its awkward and groping efforts, unquote. So, courts and other legal entities, including administrative agencies, must often decide whether a statute applies to the case at hand, and, if so, how. Courts and agencies can employ any of a number of analytical tools when interpreting statutes and other legal texts. But before we consider these tools, we should begin by examining the different philosophical approaches to statutory interpretation. One way to help understand the schools of thought about statutory interpretation is to distinguish between the schools descending from the philosophy of legal formalism and those descending from the philosophy of legal realism. Legal formalists, who largely dominated until the end of the 19th century, contended that judges' roles were limited to finding the law by applying neutral interpretive principles. Legal formalists envisioned judges as neither political nor ideological. They merely applied the statutory and constitutional provisions as written. Conversely, legal realists, whose judicial philosophy became popular early in the 20th century, took a more expansive view of judges' roles in interpreting legal texts. Realist philosophy accounted for judges' life experiences, personal, political, and ideological views, and current socioeconomic conditions beyond the statutory or constitutional language.